Chairman Issa, Ranking Member Johnson, distinguished members of this subcommittee, thank you for the opportunity to testify today on the important issues involving artificial intelligence and the impact on the creative industries. My name is Ashley Irwin, and I am currently serving my 6th term as President of the Society of Composers and Lyricists. I'm here today to advocate for my members who are already feeling the negative impact of generative artificial intelligence on their craft and its potential threat to their profession. First, some background on me and on the SCL. In my 40-plus years as a composer, arranger, and such, I have written music for over 1,000 hours of film and television and more than 3,000 commercials. Since 1990, I've provided musical compositions and arrangements for 23 Academy Award shows and been part of several Emmy-winning teams. I've had the pleasure of collaborating on many films with Oscar winners such as Clint Eastwood and Bill Conti. Over the years, my arrangements have been performed on numerous occasions for Presidents Clinton, Bush, Obama, and one of my choral orchestrations was performed during President Ronald Reagan's state funeral service. The SCL background. The Society of Composers and Lyricists is the premier organisation for music creators working in all forms of visual media. With chapters in Los Angeles, New York, and Nashville, the SCL operates as the primary voice for over 3,000 members who work as creators of scores and songs for film, television, video games, and theatre. While the SCL advocates for our members on several different fronts, the issue that has consumed the majority of our time recently has been generative AI. The rapid introduction of generative AI systems is seen as an existential threat to the livelihood and continuance of our creative professions unless immediate steps are taken on legal, interpretive, and economic fronts to address these emerging issues. I want to be very clear. My goal in raising these issues pertaining to the rights of writers and creators is not to block AI research and usage. We're simply advocating for the creation of a policy framework that ensures generative AI is developed and utilised responsibly, ethically, and with respect for human creators and copyright, so that the creative arts that are the real engine of generative AI can continue to flourish. The SCL believes that AI companies and their generative models should adhere to the fundamental 3 C's: consent, credit, and compensation. Consent by creators for the first use of their works in generative AI media. Credit, wherever audiovisual creators' works are used, and compensation at fair market rates for the ingestion of any portion of human creators' copyrighted works by AI generative machines and the subsequent output of new derivative works. I'd like to highlight 3 challenges posed to music creators by generative AI, potential solutions to which I've offered in my written testimony. Issue 1, generative AI has been equipped using copyright-protected human-authored works and programmed to mimic those works without consent, compensation, or credit. Issue 2, copyright information, metadata, has been removed during the ingestion process of these models. Issue 3, the market will be diluted due to AI-generated works. As a result, copyright protection should not be granted to AI-generated works. In closing, I thought I should address why America's success is important to me. As you can no doubt tell by my accent, I'm not originally from the United States. I came here from Australia as a young man because I wanted to be a part of the vibrant culture that is the US entertainment industry. However, the rise of generative AI poses a threat to this unique American art form. If we do not protect and nurture our human creators, we risk losing one of our greatest exports and its profound influence. It's essential to prioritise policies and regulations that safeguard the intellectual property and copyright of creators and preserve the diverse and dynamic US cultural landscape. The protection of creators is not now nor has ever been in conflict with technological development. Our founding fathers recognised that. The only place the term right is mentioned in the Constitution is with regard to intellectual property. Specifically, the rights granted to authors and inventors in Article 1, Section 8, Clause 8 are to promote the progress of science and useful arts. Respect for copyright and development of AI should go hand in hand. That way, all of humanity can benefit. I believe this committee has the power, authority, and motivation to lead that charge, and I look forward to working with every one of you to achieve that common goal.